May I mention one case from the list also? From the list. CA number 8 from daily cause list also. I have filed an IA for suspension of sentence in that case. The bench is available for till first half of the possible before rising any time it will be taken up. Because out of 1 year he's already in custody for about 5 months. 139 IR case.
First half तक ही नहीं है उसके बाद
You have not seen the notice properly.
Second half there is a DB.
Second half there is a DB and the single judge will continue after the DB. So you wait till 4:30. If it is not taken up prior to the end of the day, we will certainly take it up. And in case the DB continues for the whole day, we'll post it on Tuesday in the supplemental list. Fair enough?
Shubhan, my prayer also, Ladyship, serial number 32, contingency is there, Your Lordship. I have taken the consent from other side. They have no objection if the matter be taken up as per Your Lordship.
They have agreed for it?
Yes, Your Lordship. They have said that they have no problem, just the time.
12 o'clock?
Your Lordship, praying to mention one case, Your Lordship. This is on the list on before the court number 5, Your Lordship, for withdrawal, Your Lordship. It's a criminal revision.
Why do you want to withdraw?
Your Lordship, as per the instruction of the client.
What is the nature of the impugned order?
Your Lordship.
कुछ नहीं पता है ना?
Yeah.
नहीं चलेगा.
My Lordship, there are 2 cases, 13 and serial number 30. And kindly both the cases please discuss.
You see, there is a notice. There is a notice that the contempt matters will be taken up.
Yeah.
Right? After the DB. We will call for the contempt matters after the DB. So you just wait for some time. Okay?
Second half.
Second half. After the DB, the contempt, there is a specific notice to that effect that the contempt
पहले हो जाता है
पहले हो जाता है तो पहले हो जाएगा. आप कोर्ट को पहला केस ही नहीं करने दे रहे हैं. रुक जाइए थोड़ी देर. ठीक है?
दोनों खाली सुन लीजिएगा.
आपकी बेटी पढ़ाई कर रही है ना?
नहीं निकल गई हो गया.
निकल गई, हो गया.
Stood first in the.
Many congratulations to you for that.
Thank you. Gujarat
You have got some money. You just wait for some time.
from supplementary list. For final disclosure item 1, Penal Region 325 of 2016.
Yes.
Your Lordship, not possible. Senior is on his way.
On his way. 11:30 would be sufficient. 11:30. You have got that judgment? मिल गया था? पढ़ लिया आपने?
Item 2, Penal Region 1380 of 2016.
You also have played for short passing for argument 2, 4 and 5.
This is serial number.
2, 4
Item
and
2
5.
of supplementary list.
You are for the income tax department.
Yes.
Where is the petitioner? Petitioner is absent and there is a resolution that no coercive measures should be taken on account of non-appearance. So even if your senior comes, we will not be in a position to decide the case.
Yes.
Has Mr. Tarun Kumar come to the court? Any idea?
I have no idea.
We'll pass it over. You come at 11:30.
Yes. Okay.
Item 3, Penal Region 1435 of 2016.
Where is the petitioner?
Yes.
At the request of the learned counsel for the petitioner, the matter was directed yesterday. The matter was directed to be posted today. When the case is called out, nobody is appealing on behalf of the petitioner. However, वो resolution दिखाइए बात. However, a request has been made to this court by Advocates Association by letter dated 19/9/2024 that on account of some traffic congestion in the city, in case of non-appearance of any counsel, no adverse order be passed. Considering the request, the matter is adjourned. Tuesday तो हम लोग का कितना मैटर्स है?
फाइनल डिस्पोजल में 2 मैटर
ये भी फाइनल डिस्पोजल में है and is directed to be posted on Tuesday in the supplementary cause list. उस दिन वो नहीं भी रहेंगे तो भी हम लोग करेंगे, ठीक है? आज तो नहीं कर सकते हैं कोई एडवर्स ऑर्डर. Counsel for the state is present.
Item 4, Criminal Division 1495 of 2016.
आगे तो सर तो आ गए. Mr. Gautam Rakesh, the counsel is here. We can do this. कहाँ छूट गया? घर पे?
हम बता देते हैं रजिस्टर
नहीं ऐसे बिना फाइल के फिर आपसे कुछ सवाल पूछेंगे तो फिर आपको पता नहीं चलेगा.
2 मिनट से आ जाएगा.
ठीक.
एक केस तब तक
इस ऑर्डर को काट दीजिएगा. वो जो हम लिखाए हैं ना वो वाला बाकी केसेस में यूज होगा, इसलिए इसको टाइप करेंगे. इसको आप लेके आइए, फाइल मंगा लीजिए.
Item 4, Criminal Division 1495 of 2016.
Who is for the petitioner? This will also be taken up at 12:30. You 12:30 नहीं 11:30 बोले हैं ना इनकम टैक्स वाला मैटर्स का. This is also income tax.
Item 5, Criminal Division 1497 of 2016.
This is also same. 11:30 all these cases will be taken up, provided the counsel is there.
For admission, Item 6, Contempt Civil 504 of 2024.
Yes.
Lordship, earlier occasion, Lordship, we have filed the LPA and the LPA has been dismissed, Lordship.
So,
We had filed an LPA, LPA has been discussed, we should will file a showing the compliance, so some time may kindly be granted.
contempt case civil number 504 of 24. It is reported that the LPA filed against order dated 16th May 2024 passed in WPS number 844 of 2023 has been dismissed. Counsel for the opposite party prays for some time to file the compliance report. पूजा के पहले. पूजा के पहले.
Ladyship,
No.
4 weeks.
No. Post this case on 4th of October 24. The compliance report should be filed by 1st of October. पैसा दे के आएंगे. Let them celebrate the festival.
For hearing Item 7, Criminal Division 244 of 2016.
Yes, Mr. Tarun Kumar, your matters have been adjourned. You are appearing in those income tax matters also. No?
Yes.
They will be taken up at 11:30. Yes, what is this matter?
The office in the section 498 was the conviction sentence is the 2 years and the fine of ₹1,000 each. Petitioner number 1 is the husband option, second is the father-in-law.
This is only on the point of sentence. This case has been admitted only on the point of sentence on 12/5/2016. So you argue on the point of sentence. Petitioner number 1 is the husband.
Yes.
Petitioner number 2.
Petitioner number 2 is the father-in-law.
OP number 2 was appearing.
Yes, well, yesterday he was present in the court.
Today
Surinder Singh.
can we pass an order in his absence? आप ही लोग का resolution है तो क्या करें?
तो वेट कर लेते हैं.
वेट कर लीजिए. पास ओवर करते हैं.
कल फिर हमको बोलेंगे क्या.
नहीं, absence पे नहीं करेंगे ना. We will not assume that we will not grant you any
Yes.
relief, right? If we grant you any relief, then we will have a grievance.
Item 8, Resolution 394 of 2016.
उनको फोन करके बुलाएं.
बोल दे.
Maybe point of sentence करें. Where is the petitioner? Mr. A.K. Das. Mr. Chandrajit Mukherjee, Mr. A.K. Das, are they absent? भी तो उनके ऑफिस की थी. Ms. Swati Salim. She's from their office. The final disposal में hearing. Nobody appears on behalf of the petitioner. Are you for the stay or the on behalf of the parties? और उसके बाद वो resolution का लेकर Tuesday को supplementary list for final disposal. Record आया है ना इसका?
जी.
थर्ड केस हमारा जो फाइल
थोड़ा wait.
Item 9, Resolution 1322 of 2019.
Petitioner का कल क्यों हो जाता है? She's for OP or she's for the petitioner? बुलाइए इस वक्त सभी को बुलाइए.
From day list for final list item 1, second appeal 416 of 2016.
Respondent absent. Today we can't do anything. In absence of either parties, we will not dispose of any case. आपके इस केस का मुहूर्त नहीं निकलना. For so many dates, this matter is not being taken up. for one or the other reason, counsel for the appellant is present. Nobody appears on behalf of the respondents. वही observation देकर, okay. अब छुट्टी के बाद ही होगा, right? छुट्टी के पहले नहीं हो पाएगा. Was this case on 25th October?
25.
Yes, madam, your cases are being called out. That Lok Adalat matter, can it be settled through Lok Adalat?
Item 2, Further item 2, Contempt Civil 756 of 2023.
Mr. Girish Kumar, I think that NI Act is your case. And Ms. Swati Salim is also there. You just find out if it can be sent to Lok Adalat.
This is the contempt application by order dated 20th of August 2022. My lord has passed order directing the peaceful number.
There are so many claimants, 31 claimants.
Yes, 31 claimants, they are my raya.
May I explain?
They are my raya. Therefore, they are claiming that the money is
There
given to
there is
me.
a dispute.
Whereas this is the
Just-
Mundari.
In the supplementary affidavit, we find that there is a there are altogether 31 claimants. If the figure is correct, as I
No, 31.
31.
31 persons to whom they have to make the payment.
Yes.
And the claimants, the rayas are 8 or 9.
My lord, may I explain that what has happened, that out of the total 93.63 acres of dispossessed land, payment of 17 crores 36 lakhs 1933 has been made in respect of 51.49 acres.
Okay.
The balance area is 42.14. Out of that 42.14, 28.88 acres. This is the area in respect of which the award has been prepared in favor of the Rayat. He is not the Rayat, he is the Mundari Khatidar. So both are claiming. He has made an objection with regard to
So therefore, their claim and counterclaim or whatever is required to be adjudicated.
by
Who
the
will
authority, under section 51. Actually, the reference is made under section 76. May I read section 76?
That's right. So it requires an adjudication.
Yes,
So
yes.
this
And that has
kind
been
of
referred to the authority.
it has been referred to
It
the
has been
authority.
referred.
Where is that reference letter?
Reference.
Annexure A to G.
In your original show cause?
Actually, it is annexure A to G. G is the relevant, which is the forwarding of all the 6 awards. That is dated 13/9/2024.
13
Page 73, members.
of your show cause
The
earlier
show was filed yesterday.
On 18th.
on
On 18th.
18/9.
It
It
was
doesn't
served to
have,
him
it is
on
a
18th,
very
right?
small, it's just these many pages.
No, my lord, it is bulky.
Yesterday it was filed. I have one copy.
Okay, 18/9. Sorry, it's okay. It's here. Page number, please.
73.
What is the nature of order which is under contempt? Is there any clear direction that this amount has to be paid to you? Or irrespective of whatever the claim of others may be, is there any such order?
He was to file a representation that was to be taken.
So you have taken care
Yes.
of that representation? Now
In
the
two
matter.
parts, in 3 parts. One is for payment, one is for reference, and there is a third part also. The third part is respect to the rest 13.26 out of that left out 14.14.
Left out would be 42.14,
14.
28.88
is the 6 award
Rayyats.
Rayyati
okay,
disputed between the Rayyats and the
That's
Khatidar.
and remaining is
Remaining is 13.26 which is the Jungle Jhadi.
This is jungle jhadi.
This is jungle jhadi land. Now what has happened, my lord, there is the rate
But still,
not prescribed for jungle jhadi. Although the award has been prepared at the rate of the Rayati land, award has been prepared, that is a fact.
so why
But-
don't you pay them?
But my lord, for that, because the rate has not been prescribed for that jungle jhadi. I am saying these two things at the same
You see,
time.
once
But
the-
for that, we have referred the matter, my lords, to the deputy commissioner, and the deputy commissioner has
Once
also
the-
referred it to yesterday, my lords,
He has referred it to whom?
the secretary.
So there are two things. Do you want to suggest that this area of jungle jhadi, no compensation is to be paid ultimately, or you want to suggest that the rate is to be fixed?
The
Once
issue-
an award has been prepared,
Yeah, I am not saying not to be paid. Issue is rate.
They are
then once
disputing-
the award has been prepared, then how do you question the rate? There has to be a procedure under law, or your officers will decide the rate. Yes?
No, it is a policy decision, my lord,
What
whether
policy?
for a jungle jhadi land,
No,
the
we do
payment
not.
has to be made. Award
You
has
have
been prepared.
award has been
Award
prepared. Did you challenge the award?
No.
It can be challenged in a court of law.
Award by the government, my lord.
Why not? If the
Vigilance
government is agreed by the award, we do not know.
Not in the act provision, award to challenge.
Section 37.
You only have a remedy either to pay as per the award or challenge the award. You can't challenge it internally by talking to your higher officers. That is not permissible under law. Once the award is prepared, it becomes final. There has to be some sanctity to the award. Isn't it?
What I have found, my lords, in the act, that the corrections in the award can be made by virtue of section 33.
Okay.
That is only the clerical mistakes. This is not. So far as challenging the award in an appeal by the authority, by the special land acquisition officer,
If anybody, if you say that whatever award has been prepared is binding on the government, so you pay it. And if you want to challenge it, you can't have internal communications and change the award. Can you do it? Is there any procedure by which unilaterally the award can be changed by the government? You ask your officer, he is here for this purpose only. Yes? Is there any procedure by which you can refuse to pay the awarded amount by merely writing letters to higher authorities?
मैम पहले जो अवार्ड बना है मैम उसमें जो है एक टेक्निकल इशू हुई है उसको हम लोगों ने जब देखा फाइल को
अगर टेक्निकल इश्यू हुई है तो आप अवार्ड चैलेंज करेंगे ना?
जी
कैसे आप उसको इस तरह से यूनिलैटरली आप अपना चिट्ठी लिख के इस तरह से करेंगे?
मैम डीसी सर से मैम इस संबंध में मैंने मिला था उनसे सारी बातों को हमने जो है शेयर किया डीसी सर का एक ही डायरेक्शन था कि इस संबंध में चूंकि ये पॉलिसी डिसाइड हो सकता है
ये पॉलिसी से नहीं डिसाइड होगा। जब अवार्ड बन गया है तो आप क्या पॉलिसी? क्या आप ऐसा कोई पॉलिसी लाए हैं कि जो अवार्ड बन चुका है उसको भी सेट असाइड करके एक नया अवार्ड बना देंगे? फिर ये किस तरह का आप लोग का इंटरनल कहानी चल रहा है? एंड एट द एंड ऑफ द डे all these awarded amounts are to be paid with interest, isn't it? कौन देगा interest? Public? Who will pay the interest? For your incapacities, who will pay the interest? आप अपने ठीक से समझ के आइए, ऐसे नहीं चल सकता है कि चिट्ठी इधर उधर अवार्ड बन गया है तो आप पेमेंट करिए, सिंपल। Have you filed any execution case for the award?
No, because
No,
matter
award
is
is
pending
pending.
here and contempt is
After
pending
You
here.
go and file your execution case and get it executed.
Actually, Deputy Commissioner.
You
I
see,
have read
whatever be it, by this order, by the order of the High Court, we have not given any direction for making payment. There are multiple issues which are coming. You go and file your execution case. They are there, they don't understand. Execution method, you will get it recovered through the process of law. You will get their bank account attached, get it recovered. It's a money decree.
And the Deputy Commissioner himself wrote that you make the payment. I have annexed that.
That's right. You see, we will not issue a direction for making payment, nor we have issued a direction for making payment. In contempt, we will not go further. But only thing I can just tell you out of court is that you have a remedy to execute the award. You do whatever you want. Once it comes to the court, they will attach their property. They will not listen to all these stories, whatever they are cooking up here. Isn't it? Contempt case civil 756 of 2023. The learned counsel for the parties are present. Give his designation. Mr. So and so has also appeared before this court. The learned counsel for the opposite party has submitted that total 93.63 and odd acres of land are involved in the present case, for which 17.36 and odd crores were marked. Or this payment has been made. 17.36 and odd crore has already been paid to the petitioner, which relates to 51.49 acres. He further submits that the remaining 42.14 acres are under cloud. He has submitted that out of 42.14, 28.88 acres land, the compensation is to be paid to the rayats as per the award. For the remaining 13.26, the award has been prepared, but the land is of Jungle Jhadi. He submits that there is some confusion in connection with the rate at which the award has been prepared with reference to the said land. At this, the counsel for the petitioner has submitted that once the award has been prepared and become final, there is no scope for any communication amongst the authorities with regard to the quantum of compensation. Upon perusal of the order passed by this court finds that there was a direction issued to the respondent number 4 to do the needful with regard to the claim of the petitioners in accordance with law in the light of the statement made by the Under Secretary Water Resources Department in the counter affidavit filed, and in terms of the applicable law within a period of 8 weeks. It appears that certain disputes are being raised by the opposite party. In such circumstances, this court is not inclined to proceed any further in connection with the contempt proceedings. It is not in dispute that the award so prepared is an executable award, unless challenged by one or the other party. These contempt proceedings are accordingly closed, leaving it open to the petitioner, leaving it open to the parties to take appropriate steps as permissible under.
Okay. Thank you.
Mr. Ragnesh, your actions is not going to solve your problem.
I advise them,
I don't know.
but on my advice only the reference has been made because of the existing dispute under
They are
section
not here to advise
76.
you,
But
but it does not appear to be a remedy.
And one line is required.
reference has been made with regard to sheet number 2.
We will not say anything, but we have not referred to the reference.
No, there is some typographic error, therefore I am pointing out it. That reference has been made
We
with
have
regard
not made any mention about the reference in this particular order which we have.
Right.
Item 3 CMP 1427 of 2023.
Yes, petitioner.
May appeal on it.
What
This
is
is an
the
application
CMP
for condemnation appeal of only 18 days.
CMP
My,
or restoration.
my direction of 161023 for which time granted for remove the defect.
So you have to,
What's my
then I will just extend your time to remove the defect. That's it. You can't do anything more. Where is the order of dismissal?
there was a preemptive order by law.
Well, now there is an interlocutory order for condonation of delay. How much is the delay?
Only 18 days.
18 days. Who is for the respondent?
State.
Any objection? Okay. IA number 8064 of 2024 in CMP number. दो CMP का number दिया 1427 of 2024.
इसके registration के लिए 1071.
ठीक है. In CMP number 1427 of 2023. Counsel for the petition submits that there is a delay of 18 days in preferring the CMP. He submits that the delay may be condoned, considering the amendments made in the interlocutory application. Counsel for the state has no objection to the prayer for condonation of delays. Being satisfied with the cause shown, IA number 8064 of 2024 is hereby allowed, and delay in filing the CMP number 1427 of 23 is condoned. इसमें क्या है? This is for restoration of restoration.
CMP.
Restoration of restoration. Correct?
That means I have to first remove the defect.
Yes. This has been dismissed on account of non-compliance of.
My,
I will extend the time to remove the defect.
my.
By 20th October,
Preemptive
you
order
will.
was granted.
I will extend the time.
My,
हो जाएगा?
my.
I will extend the time till 18th October.
My.
CMP number 1427 of 2023 में. This petition has been filed for restoration of CMP number 1071 of 2023, which stood dismissed for default on account of non-compliance of order dated 6/10/2023. The learned counsel for the petitioner submits that on account of inadvertence, the defects could not be removed. And due to preemptive order, the case has been dismissed. Counsel for the state has no serious objection to the prayer for condonation of delay. With prayer for restoration, accordingly, considering the aforesaid amendments as submissions, the time for removal of defects granted by the order dated 6/10/2023 in CMP number 1071 of 2022 is extended till 18th of October.
My.
CMP number 1427 of 23 is accordingly disposed of.
Item 4 Contempt Civil 698 of 2024.
Petitioner? Yes?
Notice has been served to the opposite party number 2. Affidavit has been filed.
Yes?
Notice
notice has been served, my lord. They have filed it.
This is a contempt application in which a contempt notice was issued even in the prior case. And I was directed to get it served through the police station. That affidavit I have filed, it has been served. And it was also made open to the opposite party to engage an independent counsel.
So they have not.
So, they have
Today
not-
is a
at least
day-
they have not.
Today is a day where we do not want to pass any adverse
This
order
is-
against any
this-
client or anybody. And they have not even contacted you.
Way about it.
Who was the authority to whom the notice was to be served?
CO Burger.
Then we have no option but to initiate a proceeding against him.
Well, let me.
Not today. Today we will not do
So
it.
let it be passed over for today. And
Contempts case, civil number 698 of 2024. Counsel for the parties are present. Petitioner and the state are present. Counsel for the state has submitted that. Pursuant to order dated 28/2024, the affidavit regarding service of notice has been filed, but nobody has appeared on behalf of the opposite party number 2. उसके बाद there is वो जो है ना order, since there is a request for no coercive steps against any counsel or litigant, the matter is passed over for the day to be posted on next Friday. This is SAR case, they do not take steps, right? That is the situation.
For admission item 5, WPS 2081 of 2011.
Yes, petitioner.
Yes.
Order complied.
Yes. Clear from your,
Order has been complied.
in that order we have done.
So this contempt is to be dropped if the order.
Not continued.
So this is writ.
There
There are so many miscellaneous matters.
Miscellaneous is put in the miscellaneous
Yes,
day.
yes.
Yeah, signed matter, obviously. That's
What
right.
is it?
It matter relates to appointment of the petitioner on the post of assistant teacher in Godda district, in primary school.
Okay.
In personal advertisement, 5 note. The fact of the case is that the petitioner who has passed matriculation in the year 91 note,
Where is the list of dates?
in list of date on the synopsis to have, but apart from that, if
List
you,
of dates के लिए ना कैसे कोई case decide करेंगे? 1991 से कहानी शुरू कर.
I will find it then, this is short span of time.
WPS number 2081 of 2011. You will also file?
Yes, leadership, but what has happened, leadership, that the petitioner is claiming appointment from a, he has obtained teachers training degree from a college which was not recognized by the government of India.
At that relevant point of time.
I will
Yes,
sort
at
out
that
all the
level.
recognize.
At
The
that
document is there, that will sort.
And subsequently, a new appointment notification had also come in the year 2012. Petitioner is
We will
claiming.
decide it, right? Just on preliminary points, we will not decide the case. It is pending since 2011. Next
Seven.
Friday, we will surely decide it.
There are several orders passed in also.
Sorry?
There are several orders passed in some court also.
Must happen. But without a list of dates, I will
No,
not be
I'm-
able to dictate a judgment.
I will prepare short.
The learned counsel for the parties are present. Counsel for the parties are directed to prepare short synopsis, list of dates, and the judgments which they seek to rely upon, and also refer, photocopy लगा देंगे, refer to the provision of law. जो भी ऐसे है. The needful be done by Wednesday. Wednesday. Who is this case on trial? Final disposal?
Item 6, WPS 568 of 2014.
When do you want?
Next week.
Counsel for the petition seeks adjournment. It's a case of dismissal.
because file is traffic को फंस गए तो फाइल आया नहीं
Counterfeit. Nobody appears on behalf of the respondents. Pose this case on 25th of October.
Item 7, criminal
It's
division.
parties to file list of dates, synopsis of arguments, and the judgments they seek to rely upon this prior to the state.
Item 7, criminal division 1430 of 2016.
Petitioner. Where is the petitioner? Mr. Rajesh Kumar has not come today. This was the matter which was taken up yesterday also.
No, this is not.
No, it was taken up yesterday also.
Yesterday, similar matter.
Similar matter.
Similar matter.
Petitioner is absent. Counsel for the state is present. कोई clause लगा के hold this case for final disposal on Tuesday in the supplementary clause list. रोज list करेंगे every day, right? उसके बाद amicus appoint करके disposal कर देंगे. People can't run away from the judgment. दूसरा कोर्ट में आए
उसको देखे नहीं, सुबह से देखे नहीं.
कोई बात नहीं. Tuesday को रखते हैं. We will not pass
Monday
any
को
adverse
काल-
order anywhere
काल
against
वाला केस
anybody.
Monday है.
Sorry?
काल वाला केस जो है,
कल वाला
by
केस?
Monday. Yesterday's जो केस था.
अच्छा कल मंडे.
Monday.
उसको भी मंडे कर दीजिए. Monday for final disposal, right? You inform him.
Yes.
Item 8, criminal division 682 of 2020.
Wait, please, Your Worship. IA has been filed, Your Worship, for suspension of sentence.
Okay.
So far as the case is concerned, Your Worship, 138 NII conviction is there. Initially for 2 years it was there by a trial court, and it was modified by the appellate court for 1 year, Your Worship. Now the petitioner, Your Worship, he was arrested, Your Worship, on 24/4/2024, and till that time he is in custody, Your Worship. About 5 months.
24/4/24.
24.
And what have you stated that you have paid the amount?
No. There is a law point involved in this case, Your Worship. One point is that, Your Worship, more than 50% of the amount has been paid. Out of 7,57,060,000, 7,03,000 has already been paid, Your Worship, before filing of the
Where is
case.
OP number 2?
OP number 4 notices have not gone, Your Worship. And moreover, Your Worship, it's a premature case. For the judgment
Notice has
also.
not been issued to OP number 2.
Actually, Your Worship, he did not surrender, Your Worship, neither any exemption of surrender was
That's
filed. Therefore, the matter got dismissed for default.
Name appeared by law number 2. Pradeep Kumar Verma.
Somebody is appearing?
Kumar Verma.
Yes, Pradeep Kumar
PK Verma. Criminal Division number 682 of 2020 with IA number 9977 of 2024. The learned counsel for the petitioner submits that this interrogatory application has been filed seeking suspension of with a prayer for bail. He submits that the petitioner has been convicted for offence under section 138 of Negotiable Instruments Act. The petitioner is in custody since 24/4/2024. Considering the submissions, the IA number 9977 of 2024 is hereby allowed. The petitioner is directed to be enlarged on bail, subject to to the following conditions. Your usual है, Aadhaar and all, right? Oppose this case for the opposite party number 2 has already appeared by कहाँ है उनका वकालत करना है क्या? Where is the wakalatnama? Just check whether he has appeared or not. कहाँ है कैसे पता चलेगा? नहीं. Issue notice to the opposite party number 2. Let the records be called for from the concerned court. Hold this case under the heading for final disposal on 23rd of October. Let this order be communicated.
Notice what process?
Mr. Siddharth, notice under speed post and ordinary process.
Both.
Item 9, WPS 1884 of 2020.
Office to tax speed post. Yes, petitioner.
Your Lordship, I pray for short pass for
आज तो पास ओवर नहीं हो पाएगा. We have different board in the second. Right? You are for the High Court.
I am clear to the High Court.
Any further instructions?
No, Miss, I have not received any instructions. By the last order, my lords had issued notice to the respondent number 4.
Union of India.
No, my lords, the principal district and sessions at Dhambad who had done the recruitment. Since the State Council had submitted that he would not be representing, and my lords had directed the respondent number 4 to file a counter affidavit.
Has he filed?
Because the case status shows it has been filed, but it has not been served to me. On 24th July,
The learned counsel for the petitioner and representing learned registrar general Jharkhand High Court are present. The learned counsel for the respondent has submitted that the counter affidavit filed on behalf of respondent number 4 has not been served upon him. You will serve? You will provide him a copy? You have received a copy?
Your Lordship, I have to ask for this.
The office is directed to provide a soft copy of the counter affidavit filed by respondent number 4 to the learned counsel appearing on behalf of Jharkhand High Court at his following email ID.
I'll give you.
Pose this case on 25th October.
Item 10, Contempt Civil 442 of 2022.
Yes, petitioner. Where is the petition? Yes.
Yes, Your Lordship.
Order has been complied.
Yes, the order has not been complied, Your Lordship.
Yes.
I am not the party in this case. One supplementary affidavit has been filed. In the writ application, Eastern Coalfield Limited, the general management Bhogmairi was party. A supplementary affidavit has been filed that he may be added as a party.
He made, Your Lordship, it was
Paragraph 3 may be kindly seen that due to inadvertence, the general manager has not been made party, which was one of the opposite party in the writ petition by way of the supplementary. It is possible.
Are you there for ECL?
I am for the ECL, but ECL is not party in the contempt application.
She will make a party. What is the big deal about it?
The order is to be complied by opposite party number respondent 2, that is Secretary Mining Examination Board, that is DGMS, Your Worship. That was the direction.
The direction was to DGMS.
DGMS. The Secretary Mining Examination Board come Mine Security Director. And now Annexure 3 has been issued. Mohammed Sajad Alam is having certificate, Maulvi certificate, and by Annexure 3, page number 14, Your Worship. Inquiry is being made from.
Whom do you want to make party? Place your supplementary affidavit.
Your Worship, there was a defect that general manager has not been made party. Therefore, Your Worship, for removal.
Otherwise, you are not alleging anything against the general manager.
No.
Otherwise, you have no grievance because the direction, if there are 10 parties, if the direction is against one party, then only that party is the contender, isn't it? There is no point making everybody as a party.
But due to removal of the defects, Your Worship.
Okay, no. So, notice has to go to. Where is the? This is in defect.
No, Your Worship.
The party has to be made by name.
वो भी नहीं बना है.
किसको
बिल्कुल ही
notice
defective
है?
contempt.
This defect has not been pointed out by the office.
Your Worship, only the defect was to add the party as a general manager. No, Your Worship.
वो supplementary affidavit में one of the paragraph it says paragraph 4 Mr. PK Kundu is secretary is to be added. ये आईए application से हो ही.
Your Worship, आईए से तब होता है जब रिट में पार्टी नहीं होता है
Just
तब
a
Your
moment,
Worship.
madam.
Yes, Your Worship.
On 3.5, there was a preemptory order to remove the defects. Now it says that all the defects have been removed. Now you tell us that against whom should we issue notice in a contempt proceeding? State of Jharkhand was to be made party by supplementary affidavit, and State of Jharkhand is a necessary party in all the proceedings. You have not
But
made
it
State
was
of
not the party in
Paragraph
Your
2
Worship
they
saying-
say that state of Jharkhand is being made party opposite party number. आइए application.
भाई जरा ये जो आपने स्टैम्प रिपोर्टर ने बुलाई है, कैसे ये प्रीएम्प्टरी ऑर्डर के बाद ये बोलती हैं ऑल द डिफेक्ट्स हैव बीन रिमूव्ड?
Bishop, state of Jharkhand has been made party in Your Worship by I've added in paragraph 2, Your Worship.
In paragraph 2 you will make him party, or you will make him party in the main petition?
The main petition is to be added, Your Worship.
By way of IA application it can be done.
No,
Not
by
अच्छा है.
IA. If the defect is pointed out, you have to remove the defect by inserting the state of Jharkhand as opposite party.
In course of the day, Your Worship, क्योंकि Your Worship पूछे Your Worship the defects तो बोले कि Your Worship supplementary हम बोले फाइल कर दिए Your Worship.
जरा बुलाइए भाई इनका, हम लोग देखेंगे, ठीक है? We will give you time to remove the defects. Although there is a preemptory order, but still you do it. We do not know how is our office functioning. We do not know. The defects actually has not been removed. Right. And you have to make contemptor party by name. So how do we issue a notice in a contempt proceedings if a person is not made party by name? This person, this Secretary Mining Examination Board, what is the name of this person?
The secretary mining name is PK Kundu, Your Worship. I have mentioned in paragraph 4, Your Worship. I will add it.
Remove the defect.
Your Worship.
Contempt Civil 442 of 2022, Counsel for the Petitioner submits that she has filed a supplementary affidavit for the purposes of removal of defects. She seeks permission to carry out the necessary insertions in the contempt petition so that the defects are removed. She is permitted to do so during the course of the day. जहाँ जहाँ जो insert करना है, in blue ink you do it in blue ink. उनको भी जरा बुलाइएगा.
Item 11, Contempt Civil 650 of 2022.
Yes, petitioner.
Not complied, order has not been complied with.
What is the nature of direction?
Direction is at page 9. But on last occasion, Lord, the direction was issued to file so called. But they have not filed any so called, Lord.
They have deposited the amount.
Doctor, I don't know. But in case status note, it doesn't show anything.
Copy of order is being forwarded to judge. Not yet filed. Who is there?
Yes, sir.
Yes.
I counter affidavit and to pay cost of 5,000.
Have you
Till
done
it
that?
has same has not been done, it's our mistake, Your Lordship. Your Lordship may give a shorter time, we'll file the affidavit and the cost also. The cost, the person concerned is coming today, Your Lordship. By Monday, we'll deposit the cost and we'll file the affidavit.
Contempt case civil number 63 of 2022. Counsel for the petitioner is present. Counsel for the opposite party has joined online. Mr. Arpan Mishra. He prays for a short time to comply the order dated 28/2024. Post on next Friday. The order dated 28/2024 be complied by next Wednesday. Correct?
Item 12, Contempt Civil 191 of 2023.
Yes.
Order has not been complied with. My last
First
order
file.
dated 28/2024. My leadership directed the respondent to file the compliance report by 18/9/2024. The same has not been done.
You can't pass any court safe order today. We'll just post it on next week.
Yes, sir.
Contempt Civil 191 of 23. Counsel for the petitioner is present. Nobody appears on behalf of opposite party. In view of the request made by the Advocate Association, this court is not inclined to pass any adverse order in connection with non-appearing party. Post this case on next Friday. Yes, sir. You have filed your compliance report. Are you appearing?
I was earlier for JSMDC. Now I am not in the panel. My name appears, my lord, but now I am no longer.
For the state, Mr. Manoj
Manoj
Kumar. Who
I
is
am
for
not
JSMDC?
I am not
Mr. Manoj Kumar or Mr. Rakesh Kumar Roy?
I am not for this.
last application Manoj Kumar.
For JSMDC?
Yes,
Where is he?
and for state Rakesh Kumar.
Where is he, Mr. Manoj Kumar? You should inform
Yes,
him
Manoj
because
Kumar
if he
appears
is
for-
not appearing for JSMDC, then we have to issue notice. Isn't it? Post on next Friday.
Passport case from supplementary list for final result item 1, criminal division 325 of 2016.
Lord, one judgment has asked me that yesterday I had got for the judgment. Okay, my Lord was
Another
saying-
judgment or the same judgment?
No, that not the judgment. Yesterday my Lord had
11041.
2000 George versus State of Kerala.
Yes, yes. I've got a case.
Yes.
So there also ultimately 50,000 was
50,000
directed.
I Lord agreed.
Yesterday you had agreed for 50,000.
Madam,
Yesterday you had agreed for
yes,
50,000.
Lord. I today my Lord was.
ठीक है मैडम जजमेंट
देखिए दो तीन चीजें इसमें बहुत इम्पोर्टेंट है. One is the MBI report was done, not executed. First. Secondly, the vehicle was released in favor of another person. He claimed the ownership of the vehicle. But he has not also come as an witness that he has given the vehicle to somebody. That is not true. I think the IU has not said that he recovered the vehicle from the place of occurrence in evidence. Has he said so? The only incriminating material against the petitioner is that he has been identified by the eyewitness.
That is not only one item.
One is that sufficient.
That is sufficient.
So therefore we will modify the sentence. Right? And he was also injured.
Injured.
And there is no evidence regarding his injury report or he was there in the hospital. That has also not. So there is certain gaps.
Lastly तो डेथ कर गया भाई.
डेथ तो कर गया लेकिन इन्होंने किया कि किसने किया ये प्रश्न यहाँ पर. So उसको modify. Should I confine it to the point of sentence?
Criminal division number 28 years, having no criminal.
Present ages?
Aged 28 years now.
At that point of time.
Yes.
अभी कितना होगा?
And so this judgment was passed in 2011. तो 11-13 साल और जोड़ दिया जाएगा. And he was not having any criminal incident.
Now around 41 years.
Yeah. Well, the way I studied about happy, about the this
which paragraph?
sentencing policy. Not the in other case, okay. I am placing the two judgments. There are four the tests: crime test, criminal test, then the mitigating circumstance and aggravating circumstance, and there is proportionality test. So far, not the death sentence is concerned. No, the only not the it is added RR test, rarest of rare cases. These two. ये दूसरे केस में इस्तेमाल करेंगे.
हाँ नहीं हमको तो सेंटेंस पे करना ही है ना. Thank you so much for this. Right? उनको भी दे दीजिएगा स्टेट को सॉफ्ट फॉर्म. साइटेशन आप ले लीजिए भैया आप लोग को थोड़ा इंसिस्ट करना होगा सेंटेंस. For this judgment which I had forwarded yesterday, do you want to point out anything from this judgment?
No, but this judgment not the I am lying. Paragraph 2 paragraph not paragraph 10 and 15.
10 and 15.
There is also not the case related to 304A,
yes.
38.
Okay. Heard the learned counsel for the parties. During the course of hearing, the learned counsel for the petitioner, senior counsel for the petitioner has confined his arguments on the point of sentence. The learned counsel submits that the petitioner has been convicted for offence under section 279, 337, 338 and 304 capital A. And he has been sentenced for to undergo RI for 3 months under section 279 IPC, RI for 3 months under section 337 IPC, RI for 1 year under section 338 IPC and also under section 304 IPC, and all the sentences have been directed to non-conformity. The petitioner has been further granted the benefit of section 428 IPC. The learned counsel submits that the petitioner was 28 years of age at the time of accident and 28 years of age on the date of conviction. And more than 13 years have elapsed. The petitioner has got no other criminal case against him as per the available record. He has further submitted that the petitioner has remained in custody during the period from 24/2016 till 12/5/2016 at the stage of revision. The learned counsel has also submitted that in the accident, the deceased as well as the petitioner had suffered injuries, and both of them were taken to the hospital. And in the hospital, the victim ultimately succumbed to injuries. The accident had taken place while the petitioner was driving a motorcycle and had hit the deceased. The learned counsel has also submitted that the LBI report of the motorcycle was not exhibited before the court, and the exact reason for the accident has not come up before the courts. The learned counsel submits that the vehicle was released in favor of third person who was the owner of the vehicle, but he was also not examined as a witness before the court. However, he has submitted that considering the entire facts and circumstances, the sentence be reduced, and for that purpose he has relied upon the judgment passed by the Honorable Supreme Court in SLP criminal number 11041 of 2024, George versus State of Kerala, and has submitted that the Honorable Supreme Court has clearly observed and has submitted that the said case was also arising out of offence punishable under section 279, 337, 338 and 304 capital A. And the Honorable Supreme Court, the concerned High Court had reduced the punishment to 6 months with fine of rupees 2.5 lakhs, Sana, with a fine of rupees with compensation of rupees 2.5 lakhs, and ultimately, and it was also found that the appellant was arrested and was in custody when the case was taken up by the Honorable Supreme Court. The Honorable Supreme Court ultimately upheld the conviction, and reduced the compensation amount to 50,000. लेकिन 6 महीना का तो रख दिए थे ना?
6 months में उसको पेमेंट करने के लिए 60 days.
Yes, and the sentence was confined to the period undergone. The learned counsel for the opposite party, state, has submitted that in case this court is inclined to modify the sentence of the petitioner, then fine amount be imposed, which could be remitted to the legal representative of the deceased. Yeah? After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that both the petitioner as well as the deceased got injured in the same accident, and the petitioner was driving the vehicle. The deceased, both of them were taken to the hospital, and the deceased succumbed to injury in the hospital. The doctor has also been examined, and the story mentioned in the FIR was corroborative with the evidence of the doctor. PW4 was the informant of the case who had identified the petitioner. However, the NBI report was not exhibited, and admittedly the vehicle was released in favor of third person who had filed documents for release of the vehicle. This court also finds that the injury report of the petitioner was also not इसको last sentence. The petitioner was, considering the judgments passed by the court, this court finds that both the courts have passed well-reasoned judgment so far as the conviction is concerned, and the same does not call for any interference. However, the fact remains that more than 13 years have elapsed from the date of the incident, and the petitioner has also remained in custody for some period. And has faced the trial, the criminal case for a long time. No other criminal case in connection with the petitioner has been brought on record. Considering the totality of facts and circumstances, this court is inclined to modify the sentence of the petitioner to the period already undergone in judicial custody, with a fine of ₹50,000 to be deposited by the petitioner within a period of 3 months. 3 months? 3 months from the date of communication of this order to the concerned court. If the fine amount is not deposited within the stipulated time, the petitioner will serve the sentence as awarded by the learned court. And the learned court shall take all steps to ensure the arrest of the petitioner. The fine amount so deposited is directed to be remitted to the victim, to the legal representative of the victim after due identification. This petition is disposed of with the appropriate modification of sentence.
Also, case item 2, criminal division 1380 of 2016.
Yes, how do you sustain the conviction?
Again, rely on 278E because the onus was on the accused to prove that by way of documentary evidences that there is.
What documentary? If a person says I am totally unconnected, what documentary evidence will you produce?
At the same time, he was the.
At least you see, there should be some material against the petitioner.
Yes,
You have the only material against the petitioner is the show cause filed by the co-accused.
Yes, ma'am. Yes,
Can
ma'am.
it
But
be a
at the same
material
time,
against the petitioner?
there was a notice issued to the accused also as to the allegations, and there was no reply tendered by the accused.
That is sufficient.
Yes, my lady, but at the same time, he also not substantiated on the fact that why did he not reply to the notice, and it is not the case in this particular case itself. This is the same case in the several other cases also, that he has not replied even to a single notice. This must have raised some kind of alarm that why is such kind, if at all it is a frivolous allegation, why is such frivolous allegation being raised against the accused again and again and again by different SSCs. It is not so that the SSCs are colluding, all the SSCs are colluding against Mr. Satyavan Ray and they are making such kind of allegations.
That is not sufficient to convict a person. Merely because a person does not respond to your notice, that does not mean that you will convict him in a criminal case. That is the only material?
That is the only material. And as far as the deposition of the SSC was, she might have been convicted or she might have...
She has been convicted.
Yes, ma'am.
She has been convicted.
So again, bringing that SSC to the cross-examination table would have been like asking her to be the approver in that case. I'm not sure if the proceeding in that direction was initiated by the department or not.
And so far as she is concerned,
yes, ma'am.
She has put her signature in
Yes,
the form,
yes, ma'am.
in the Saral form.
Yes, ma'am.
And subsequently she started putting thumb impression. Isn't it?
Yes, ma'am.
So
that is the contradictions are evident on the face of it.
difficult to sustain this conviction.
It's the improvisation that the SSC has made subsequently.
Is he a beneficiary of the entire transaction by any means?
Yes, ma'am.
How?
Because he may be deriving some sort of commission from that by the time you get the refund, I'll take this much amount of commission.
That is not the evidence. That is not the evidence.
That has not been pleaded, I mean, in the trial court below, but certainly he could have been the beneficiary. I mean,
no, we will not.
The authorized representative do charge commission a certain amount of the work that they do for the SSCs.
नहीं चलेगा आपका ये करना। आपने इनसे क्वेश्चन भी नहीं पूछा है कि आपको शोकॉस की आप जवाब क्यों नहीं देते। C13 में वो क्वेश्चन भी नहीं। His signature on the receipt of the showcause reply is also not exhibited.
Those discrepancies are evident on the face.
नहीं चलेगा। आपको कुछ और लोगों से एविडेंस लेना चाहिए था कि दूसरे केसेस में एक्यूज्ड है, चाहे जो भी कुछ करते हैं, रेस केस में एक्यूज नहीं है, वो सब तो आप किए नहीं। मेन एक्यूज्ड को और अबेटर को तो अलग अलग केस में आप एक्यूज बनाओ। how will the main accused become an give evidence against herself here? We do not know. She could have given evidence saying that he is the person who did all this. We do not know. But on the basis of material on record, there is nothing to link the petitioner except that he did not file his reply petitions. That cannot be, and that has been taken as a circumstance to convict him.
Also the tenets of 278E.
278E will come into play
Yes.
only when there is something against the person. Mere non-filing of a reply to show cause is sufficient. Show me 278A. नहीं जल्दी करो. 278A.
E, my lady.
Let us see that non-filing a reply to a show cause will also give a presumption. (278E).
Yes, sir.
Read it.
Presumption has to be as to culpable mental state. In any prosecution for any offence under this Act, which requires a culpable mental state on the part of the accused, the court shall presume the existence of such mental state, but it shall be a defence for the accused to prove the fact that he had no such mental state with respect to the act charged as an offence in that prosecution. Explanation: in this section, culpable mental state includes intention, motive, or knowledge of a fact, or belief in, or reason to believe a fact. For the purpose of this section, a fact is said to be proved only when the court believes it to exist beyond reasonable doubt, and not merely when its existence is established by the preponderance of the probability.
Subsection 2 with the preponderance of probability से ही आप exist कर रहा है इनका mental state.
Yes.
नहीं? इस पे judgment है subsection 2 पर.
The only judgment that I can fetch is that as to the interpretation of the statute, which says that the jurisprudence of the other laws should not be used to interpret.
No, there is no question of using the jurisprudence of other laws.
Certainly.
But merely because a person does not reply to a show cause notice, is it not you are taking it by way of preponderance of probability only? Merely because a person does not respond to a show cause notice, can it be a circumstance to convict a person?
At the same time, it is the deposition of the respective assessee in their respective complaints that he or she was induced by the accused Satyavan Ray for signing, undertaking the false signature.
Those
under
depositions have been exhibited.
Those depositions have been exhibited. That had not been. Might be the parallel proceedings were running and all the depositions were running simultaneously, so it would have not been possible for the prosecution to exhibit those depositions.
And those persons have also been convicted by
Yes, ma'am.
by the aid of section 278.
By the aid of 277 for the false verification that they have undertaken.
Yes, for the first verification.
Yes.
So if they have been convicted by aid of section 277,
Yes, ma'am.
and the very fact that they had signed the verification
Yes, ma'am.
is fully attributable to them only, then under such circumstances, how does an abettor come into picture?
Because they passed on the information to the department that they were induced by the accused Satyavan Ray for undertaking such kind of signature. I mean, the court itself had made an observation the other day that we always make some kind of arrangements with our chartered accountants, with the authorized representative.
मेरा observation से थोड़ी होता है.
I mean, I'm persuading to that extent, my lady.
(278E2) में कोई judgment नहीं है. You are always going through a few judgments.
Yes, ma'am. Mangatram Narota that I had.
Have you got a copy of that?
I'm
The दूसरे file में.
carrying
If you have a copy of that, please provide. And he has also remained in custody for some time.
Yes, madam. 2 or 3 months he was in custody.
You have got a copy of the judgment?
No, my lady, I'm not getting.
Yes. You are here? तो DFD नहीं हुआ था क्या? जब बताइए.
ऐसे काम करना ऐसे तो उन्होंने काम किया था इसमें मिस्टेक में काम करना चाहिए
State as per SC. और जो पार्टी नेम नहीं है बाय नेम होता है ना कंटेम्प्ट. नहीं स्टेट तो ठीक है नेसेसरी पार्टी है लेकिन कंटेम्नर का तो नाम होता है ना तो वो डिफेक्ट भी नहीं है इसमें. SC से तो नहीं होता है ना इस तरह से. और ये ऑपोजिट पार्टी में भी मेड पार्टी बाय नेम बाय सप्लीमेंट्री है.
सिर्फ हम लोगों ने डिफेक्ट नंबर 1 में हम ऐड कर देते नेसेसरी करेक्शन में आल्सो पेमेंट कॉस्ट है वो तो एकदम डिफेक्ट सही है.
ये सारे तो डिफेक्ट्स हम लोग तो परमिट करते हैं ना हाथ से करने के लिए स्टेट ऑफ झारखंड को बनाना या पार्टी को. इससे क्या होता है कि सप्लीमेंट्री एफिडेविट तो फाइल हो जाता है लेकिन रिकॉर्ड उसमें नहीं आ पाता है तो दैट इज अ प्रॉब्लम. तो वो ना जब भी आप इस तरह का हो तो यहाँ पे लिख दीजिए एप्रोप्रिएट ऑटोमेटिक पास कर जाता है रिव्यू ऑफ द सप्लीमेंट such that we permit them to do the corrections. ठीक है? You had cited 2 judgments, I remember.
Yes, ma'am. Both were with respect to 277 and 278.
Can you mail it to the courtmaster?
If I may pass the soft copy.
Fine. That's right. You listen to God. Let us see the improved judgment on a moment. The trial court judgment. And
Yes.
what is the material against the petitioner? Only that discussion.
Yes. But it is mentioned in the prosecution report also that she disclosed the name of the petitioner as a abettor, and she admitted that she has produced all the documents for the income tax department, and it has not come in the entire record also, in whose presence this petitioner has said to file those documents, and they have also not been examined, except the name taken by the SSC. There is nothing against this petition.
Where you say that she said that she filed the return herself, the accused to whom she claimed to have handed over the said return duly signed by her.
Duly signed by her. Duly signed by her.
All right. We come to the findings, please.
Yes.
What is the material against the petitioner?
Well, in this case, only the three witnesses examined. The one Balram Kumar Mandal is the steno. He has only identified and proved the prosecution sanction order of the Commissioner Income Tax. That is Exhibit 1.
That is a sanction.
Yes,
Exhibit 1 is the prosecution sanction, and CW2 is speaking Bush.
The Exhibit 1 is the order dated 18/1/2005 sanction prosecution of accused passed by the Commissioner of Income Tax. Exhibit 2 is the certificate of the judgment dated 29/5.
Exhibit 7 is the show cause notice to the accused.
Yes, ma'am.
And Exhibit 8 is the complaint petition. Come to para number 13.
Yes. It appears that the CW1, namely the Balram Kumar Mandal, is the stenographer of the Income Tax Department, Dhanbad, and was posted as a steno in the said department on the 18/1/2005 in the office of the Commissioner of the Income Tax, Dhanbad, namely Shri Balram, and he has identified the proof the order dated 18/1/2005 sanction prosecution of the accused passed by the aforementioned Commissioner of Income Tax, Dhanbad, and namely Shri Brajlal. This witness has stated in his examination in chief that there is being a steno in the office of the Commissioner of Income Tax and typed this in. The same has been marked as Exhibit 1. In such circumstance, it is not mandatory that the document Exhibit 1 must only be identified and proved by the signatory. Thereof, who is the Commissioner of Income Tax, Dhanbad, CW1.
Sorry, you come to this para number 14.
It appears that the exhibit number 3 is the income tax return filed by the SSC.
Just four lines above that. That witness has identified and proved. The 4 lines about that. The witness has identified and proved.
Further stated that Satyavan Rai was thereafter the issue a so-cause notice as to whether prosecution under Section 278 of Income Tax Act be not be launched against him in the matter. In this witness has identified the proof during said so-cause notice to the Satyavan Rai, that is Exhibit 7. He has further stated that Satyavan Rai has not replied to the said notices. This witness has lastly identified and proved the complaint petition of the present case in his signature. Thereof, the same has been marked as Exhibit 8.
Para number 14.
Yes, ma'am. It appears that the exhibit number 3 is the income tax return filed by the SSC, namely Srimati Munilal Devi, for assessment year of 2003-4, and it bears the signature of the Munilal Devi upon the verification portion thereof, the which mention the document of LIC premium, paid certificate, and the bank loan paper in respect of which the inquiry was conducted by the Income Tax Department, wherein the Chirkunda branch of the Bank of India through the exhibit number 4/1 has stated that the SSC, namely Munilal Devi, has no housing loan account bearing number 1263 with their branch as claimed by the SSC in her income tax return. It further appears that the Chirkunda branch of the LIC of the India has also stated through the exhibit number 5/1 the agency code numbers 06332592. Munilal Devi is not attached to their branch. Accordingly, the reply of the Chirkunda branch of the Bank of India and the Chirkunda branch of the LIC of India.
You just come to the bottom. This shows that.
Yes, ma'am.
Just to the bottom. This shows that the SSC, namely
Munilal Devi.
Padi last line, last 2 lines of the same page.
Yes, ma'am. The SSC, namely Munilal Devi, abated by the present accused by filing her false income tax return for assessment year 2003-4. So far, the non-examination of the SSC, namely Munilal Devi, the concern, it does not affect the credibility of her reply as contained in
So
the.
this is perverse, right?
Yes,
the judge says that non-examination of Muni Devi
Yes.
does not have any bearing because her show cause reply is sufficient.
Yes.
This is ex special purpose. We just have to take it. We will not take this. There is no material against him. Appellate order?
Has the burden proof?
The conviction
Burden
was-
of proof से भी नहीं चलेगा. देखिए.
If I conclusively, if I may address the court to the aspect of the modus operandi of the accused. The Honorable Court may have noted in the several other cases that had come before itself that the same modus operandi was used. LIC was the institution, housing loan was the institution, housing loan was the aspect, loss in the construction of the house. Those were the issues.
The entire
modus operandi is
transaction, so
exactly-
far as the SEC is concerned, is absolutely clear. But how do you link the petition?
Invariably, in all the cases, the modus operandi is same.
So
it cannot be attributed that they all have colluded simultaneously and executed the same kind of modus operandi.
So who is the person?
It's the
What
accused.
is it? What is it that takes only to the accused?
Is
Is the
their
accused,
association with them?
if somebody is
He was a
making a
concerned-
statement against the accused that he has abated that person to commit a crime,
Yes.
is that accused entitled for a cross-examination of that person or not?
Yes, my lady. But at the same time, the accused has not put question to the concerned officers that are the income tax officers that this why the accused have.
Income tax officers are working on hearsay, completely hearsay. Some person is saying that this person has abated me to commit the offence, and that person will not come to the dock for examination and cross-examination. You could have taken steps that, okay, for this particular case, you produce somebody else. Because there is a racket, according to you. Nothing, you have not done the need.
Due prior to differ, my lady, it may have been the case a hearsay in one particular case, but it cannot be the hearsay in all the cases, because there may have been the occurrence of such events in that direction.
See,
so that may have propelled.
Income tax department thinks that except income tax department, everybody is to be treated with cloud, right? That is not the case. We will go strictly by the criminal jurisprudence. Apart from that, we will just consider the presumption. That presumption also will not come into play, and the Act clearly says that it is not a case that in all cases you will presume. The moment you issue notice, you will presume. No. If it is on preponderance of probability, then you cannot presume. Merely by non-replying to your show cause is not a material to convict the petitioner. Yes, State, do you have to say anything? You don't have to say anything. Criminal Revision number 1380 of 2016. For the learned counsel for the parties. This revision has been directed against the judgment dated 5th of July 2016, passed by Additional Sessions Judge Roman 13 Dhanbad in Criminal Appeal number 37 of 2016, whereby he has dismissed the appeal filed by the petitioner against the judgment of conviction and order of sentence dated 12/2/2016, passed by learned special judge within bracket economic offence bracket close Dhanbad in CO case number 20 of 2005 under section 278 of Income Tax Act. The petitioner has been sentenced to undergo rigorous imprisonment for a period of 2 years and fine of ₹5,000 with default sentence. The learned counsel for the petitioner submits that the judgments passed by the courts are perverse and they call for interference. He submits that the petitioner was that as per the allegation, the petitioner was said to have abated one Munilal Devi to file false return and claim refund by disclosing housing loan and Form 60 and by filing Form 16 capital A allegedly issued by LIC Chirkunda branch showing TDS certificate. Both these documents were ultimately found to be forged. The Learned Counsel submits that the conviction of the petitioner has been made solely on account of the reason that Munilal Devi had disclosed to the Income Tax Department in her show cause reply that it is the petitioner who is responsible, who had abated her to file false returns. The Learned Counsel submits that another circumstance which has been used against the petitioner is that he did not respond to the show cause reply, to the show cause notice within bracket Exhibit C. The Learned Counsel has further submitted that the Learned Trial Court has taken a view that non-examination of Munilal in the case has no bearing in the matter, and it does not affect the credibility of a reply which was marked as Exhibit 6. The Learned Court has also observed that it could have been done even by that she could have been examined even by the accused in order to falsify her reply, but nothing was done on behalf of the accused. The Learned Counsel submits that the conviction of the petitioner cannot be sustained even by the aid of Section 278 capital E of the Income Tax Act 1961. He has referred to subsection 2 thereof, that which clearly postulates that a fact is said to be proved only when the court believes it to exist beyond reasonable doubt, and not merely when the existence is established by a preponderance of probability. The Learned Counsel submits that non-filing of reply to the show cause and is itself a circumstance by way of preponderance of probability, and the same cannot be used against the petitioner to convict the petitioner for offence under Section 278 of Income Tax Act for abating filing of false return by Munilal. That's it?
Yes, sir.
The Learned Counsel, appearing on behalf of the Income Tax Department while opposing the prayer, has submitted that there are two concurrent courts have held the petitioner guilty, and there is no scope for reappreciation of materials and coming to a different finding in absence of any material irregularity, perversity. He has referred to the judgment passed by the Honorable Supreme Court, reported in bracket 2011, bracket close 12, taxman.com 67. This is the citation. You just provide a copy to us.
Yes,
within bracket SC. Income Tax Officer Jind versus Magat Ram Nurata Ram Narvana, and has submitted that the presumption under Section 3 378 capital E.
278.
278 capital E has been rightly utilized against the petitioner. He has also submitted that Munilal Devi could not have been examined as she was a co-accused in connection with the same transaction. Yeah? After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that admittedly Munilal Devi was having a PAN number and was an SSC within the meaning of Income Tax Act 1961, and she had filed her return for the assessment year 2003-2004 along with TDS certificate claimed to be issued by LIC of India and also showing repayment of housing loan and claimed refund of rupees 53,760. These documents produced on for claiming refund were found to be forged, and when a show cause notice was issued to her, she admitted her signature in the verification portion of the return and disclosed the name of the present petitioner and stated that the petitioner, that she had handed over the return duly signed to the petitioner. And the information and return were fabricated and managed by the petitioner. On the basis of the petitioner, on the basis of the complaint filed, the complainant had examined 2 witnesses before the court, and following documents were exhibited. The exhibited documents included the certified copy of the judgment dated 29/5/2014 in Criminal Appeal number 49 of 2014 passed by Learned Sessions Judge Dhanbad, convicting Munilal Devi for the offence under section 277 of Income Tax Act. The various documents also which were exhibited included the show cause notice dated 17/6/2024 said to have been issued to the petitioner, and it was asserted that the petitioner did not respond to the show cause notice. The learned trial court scrutinized the materials on record, including the documents relating to following documents करते हैं, इसको list बना देंगे, page number 20. The learned court, while convicting the petitioner, has relied upon the show cause reply filed by Munilal Devi. The learned court held as under. यहाँ से quote करेंगे, page number 23 से. Thereafter, the learned court referred to section 278 of Income Tax Department of Income Tax Act, and was of the view that the case of the petitioner falls into the 3rd clause and explanation of section 107 of Indian Penal Code, and ultimately held as under. यहाँ पर पेज नंबर 25 से कोट करेंगे. this court finds that IPC teacher. Upon the perusal of the judgment passed by the learned trial court, this court finds that the petitioner has been convicted on the basis of the show cause reply filed by Munilal Devi, assuming the reply to be a gospel truth, and further the learned court has given justification further the learned court has also held that the non-examination of Munilal Devi does not affect credibility of a reply within bracket exhibit 6, and the petitioner also could have brought her as a witness to cross-examine in order to falsify her reply, but nothing was done on behalf of the petitioner. This court is of the considered view that the prosecution has completely failed to establish the case against the petitioner by cogent material inasmuch as the reply filed by Munilal Devi, which became the basis for conviction of the petitioner, could not have been relied upon by the prosecution without examining Munilal Devi as a witness in the matter, so that the petitioner could have an opportunity to cross-examine her. This court is also of the considered view that except the show cause reply filed by Munilal Devi, there is no material to connect the petitioner with the alleged offence. The reliance on section 278 capital E of Income Tax Act is also misconceived in view of the fact that section 278 within the capital E subsection 2 clearly provides that a fact is said to be proved only when the court believes it to exist beyond reasonable doubt, and not merely when the existence is established by a preponderance of probability. This court is of the considered view that merely non-replying to the show cause notice issued by the Income Tax Department by the petitioner by itself cannot be a reason to draw any presumption with regard to the culpable mental state of the petitioner, unless there was some material against the petitioner to draw such a presumption. No such material. This court is also of the view that non-examination of Munilal Devi has highly prejudiced the petitioner, and it was for the Income Tax Department to get her examined and cross-examined in order to convict the petitioner for abatement of offence committed by Munilal Devi. The fact remains that Munilal Devi had put her signature, has been convicted for offence under section 277 of Income Tax Act. The returns filed by Munilal Devi has been exhibited, which indicates that Munilal Devi had put her signature on the form. The Honorable Supreme Court in the judgment passed in the case of Income Tax Officer Jin versus Madhukar Ram Nurata Ram Narvana, has clearly held that once a person puts signature on the verification form, then under such circumstances he cannot wriggle out from its responsibility. And the provision of section 278 capital E comes into play. इसमें था ना 278 E? नहीं.
इसमें 278.
हाँ. Then the person cannot wriggle out from the such evidence is a strong evidence against the maker, but he is at liberty to prove that such admission was mistaken or untrue. Okay?
Yes.
Para 10 इसका quote करना है. Considering these aspects of the matter have also not been properly considered by the learned appellate court, in view of the aforesaid facts and circumstances, this court is of the considered view that the conviction of the petitioner cannot be sustained in the eyes of law, and in order to secure the ends of justice, the impugned judgment of conviction of the petitioner are hereby sentenced. There will be a lot of corrections. If I get one judgment, I have not brought that judgment, I will just put it regarding how the onus on this 278 capital E subsection 2. What is the role of that? I'll cite a judgment. और एक और केस है सेम?
दो केसेस और दो
आइडेंटिकल
है, बस थोड़ा सा वेरिएंस है, वही कि I did not reply to it. I mean, in that the question was put to the accused, why did you reply to it? He said that I did not reply to it.
In 313?
Yes, ma'am. I'm not sure if it was asked in 313, but that has been recorded in the judgment.
Okay, इसमें जो है ना, इसमें एक चीज़ और लिखी है. This court also finds that no question was put to the petitioner under section 313 of CRPC with regard to the receipt of the show cause notice or as to the reason as to why he did not reply to the notice. इसमें नहीं.
इसमें नहीं है, लेकिन बाकी सब में
कोई बात नहीं, उसको भी डील करेंगे. उससे भी कुछ नहीं होता. कोई शो कॉज नोटिस का जवाब नहीं देगा तो आप उसको कन्विक्ट कर देंगे. दिस इज नॉट डन.
Story is the same, also only the name of the SSC has been changed.
The SSC was also convicted.
Conviction order उनका exhibit हुआ है?
Yes.
That has been recorded in the judgment.
Exactly.
This is Satyapan Roy, right?
Yes.
Same finding है?
Same.
With regard
same.
to cross examination?
Yes.
दिखाइए भाई. Every order is a different order. He does not remember the case lodged.
Madam, can you see the same version has come also? The same time they are examining the SSC, namely page 10. Sorry, running page 28.
Running page 20.
Yeah. the same time, the examining the SSC, namely Munna Chatterjee is also not necessary in view of her own assertion against the present accused in her own reply, as contained in the Exhibit 9. It could have been done by the present accused, but nothing as such has been done by or on behalf of the present accused.
It is also the same story.
Yes, ma'am.
Munna Chatterjee is the person,
Yes.
and Mrs. Munna Chatterjee, right? Where is his conviction judgment?
Conviction judgment has not been annexed in the revision, but it has been recorded in the judgment itself.
Exhibit 2, the certified copy of the judgment dated 16/5/2014.
Exhibit 2.
Yes, ma'am. Passed in criminal appeal number 2000-2013.
Same order for this also. और इनका है कोई केस?
एक उसमें भी SSC मुनीलाल है. Next one.
अच्छा, for a different assessment year.
Yes.
And the same story.
Same story.
ये तीनों केस सेम. और कौन सा है?
बस पूरा.
हो गया आपका काम? और भी बाकी है?
आज का तो there are 15-20 cases more of सत्यपाल.
इसको टेस्ट करेंगे आपसे क्यों करते हैं करिए.
It's in the nature of a wheel that if the court may be inclined to lift and see the kind of a scam that the
जैसे
accused has
एक केस में हम दूसरे केस का कहानी नहीं बुझा.
Certainly.
Right?
That is
क्योंकि वो कहानी आप रिकॉर्ड पे नहीं लाए.
yes.
वो नहीं करेंगे ना. Every case is a different case. शो कॉज रिप्लाई फाइल नहीं करने से आप किसी को कन्विक्शन नहीं करते. This is my view subject to what ultimately happens. हो गया? चलो. हाँ 12 बजे जो फिक्स है.
This case item 32 from Delhi based Contempt Civil 683 of 2024.
If I may be permitted, very briefly, I will try to recap everything. The order states
So first let me ask them what happened to
My
LP.
lords, we mentioned the LPA. We have filed supplementary. LPA is defective. We have got the LPA number. LPA number is 489 of 2024. And personally, my lords, of the record, I may permit to say,
asked my clerk also, I also visited the section. They said that it is likely to be listed next Tuesday, coming Tuesday. This is of the record which I am seeing.
आपको supplementary affidavit में कुछ और फाइल करना
एक सप्लीमेंट्री एक फाइल की लॉर्डशिप जहाँ पे बोले कि हम लोग मेंशन जो किए उसमें बोला गया यूजुअल कोर्स में. That was
usual course will come out
that was on
come
10th
up on Tuesday.
That was on 10th September. 10 सितंबर का है. उसके बाद फिर
देखिए आपका जो oral submission
नहीं,
से
हम
नहीं
बस-
चल सकता, please hold on.
नहीं, हम-
Because the day you said that the defects have been removed, actually it was not removed. So we will not take your oral submissions. As per your supplementary affidavit, the case is to be listed in
usual course. And lordship,
So you comply the order.
the updated position is LPA 489. We have got the case number. Case number मिल गया. That means the defect has been removed. It is showing the defect has been removed. So and lordship may just if lordship may because this is what endeavor which we have put forward. This is what we have received. And lordship, this is what I am saying. Submitting my lords. Lordship may if permitted my lords, this can come up on next Friday. Because I do believe it will be taken up on Tuesday, my lords. I know I'm conscious.
From where do you say this? Because your submissions which are recorded in black and white
In black
are
and
not correct.
See, this is the High Court.
Today, I'm talking about today's.
I'm talking about
19th.
19th. You submitted the typed copy on 19th.
99. There was the earlier typed copy. They said that this also requires some more additions. That's why the fresh typed copy was submitted on 19th. Yesterday. And we got the number, that is LP 14/2024, and it is showing on the online portal also all defects removed. दिखला भी रहा है.
But there are submissions recorded on your behalf that the defects have been
My
removed.
lord, there was further stamp reporting which was occasioned this matter. Our submission was specific, all defects were removed. Thereafter, further stamp reporting was also done. We removed all the defects which are pointed out pursuant to the further stamp reporting.
You see, as long as there is no stay,
My
you
lords.
comply the order. Simple.
My lords, we have
What
also,
you have to do? You
we
have
have-
to pass an order. What is it that you have to do?
My lords, we have also filed an IA, my lords, to that effect, my lords,
What effect?
to defer the hearing
Till the disposal of LPA. Because I need 5 minutes. In fact, in Form 1, under Rule 393 of the Jharkhand High Court rules, a notice has to go to the Chief Secretary. I'll just in 5 minutes let me narrate how the thing has transpired. Your Lordship's judgment and the direction contained therein had to be complied latest by 1st of August 2024. First order of your Lordships is dated 9/8/2024, whereby notices were issued to the Chief Secretary, received on 11th of August. Then, your Lordships heard this matter on 23rd, wherein a plea was taken and an LPA has been filed. Token number was mentioned as 7361 of 2024. Said to have been filed on 17th of August 2024. If we take that particular date, 17/7, the date of filing. This is one aspect of contempt. There are other aspects which are flowing from supplementary affidavit, which makes this case a gross case of contempt, that the High Court may pass any judgment, any direction. We take a decision to file appeal. The High Court order is possibly pales into oblivion and will not comply with that. It has to be ignored. I'll show that, but first the dates. 17/8/2024. We are today on 29/2024. A period of 32 days from the date as per them that they filed it with defects. Your Lordships, in view of that, as every proceeding of this Honourable Court is captured in YouTube, time and again on that very day said, all right, you mention it, obtain a stay order, come before this court, if the division bench stays it, showing deference to the filing of an LPA. No, so on 23rd, your lordships fixed it on 38th. No, 38th again, not cured. 31st, the next day that your lordships heard it, and then your lordships passed a detailed judgment. Now, my lords, if your lordships will kindly see, detailed order, sorry, my lords, 31/8/2024, where your lordships was prima facie, kindly see the order, this is order number 4. Has your lordship got it? It's a detailed order. Your lordships have quoted para 7 of my supplementary apart from your lordship's own prima facie findings. And kindly turn to the next page, my lord, last page. Consequently, the opposite party number 2 is directed to file show cause as to why a contempt proceeding be not initiated. And prior thereto, your lordships have prima says.
Yes, I remember this.
No, and then
So this
what kind of a
show
show?
cause has been filed?
No,
Show cause we have filed.
no, show cause.
Let me just
The-
see the show cause.
No, kindly see that. I'm trying to point out first. Show cause has been affidavitted by a deputy secretary. Show cause of opposite party number 2. I will tell the name, Roshan Kumar. Kindly see. आप देख रहे हैं, आप जो कॉपी हमको सर्व किए हैं उसमें वही दिखाता है. आज
It was filed on 38/21.
10th September 2024.
10 September 2000.
That's 10th September, your lordship's order of 39, 31.
31st August, तो उसके बाद ही फाइल करेंगे.
10th September.
No, 10th September, it had been signed by the chief secretary. Now, kindly see a day
That
before
mistake
yesterday is.
That is a supplementary affidavit indicating that it is now going to be listed in usual
Now,
course.
kindly see one thing. That's. Kindly see one thing. This is first aspect. 32 days from, 33 days from the filing of the LP.
See, we will go only by your record, right? You have said that now the case will be listed in usual course. So you comply the order.
May just take record of one more important aspect. As per the new SOP, we get the LPA number only once the case is defect free. As per
And you have removed the defect only day before yesterday.
my lords, and we have got the LPA number.
That's right. You have done a great job.
My lords,
You have taken 1 month to remove the defect.
my lord, there was further stamp
In a
reporting this
case,
matter.
in a case where the chief secretary of the Jharkhand is the contender, it takes 1 month.
There was further stamp reporting the matter. So that took us, that was after 31st. After 31st. I was only playing this case is because I've got reasons to believe this case is likely to be listed on Tuesday next. I was only playing this case may come up on next Friday.
No, next Friday. The point is that today we are going to initiate a proceeding.
My lords,
Now
for that, my lord, I filed an IA to that effect, my lords, because I am also relying upon a Supreme Court order to that effect. Lordship may kindly permit me to place the IA. IA 9990 of 2024.
Because that is why I was trying. 5 short, brief points in 5 minutes. If my learned friend can permit.
Because the Honorable Court posed a.
Now, kindly see the para 1 of this IA. That by way of the instant application, the opposite parties prayed before this Honorable Court for deferring the hearing of the present contempt application till disposal of the LPA preferred, being LPA file number so and so. Mere filing, my lords, I am not aware of any law to this effect. Mere filing, then a judgment and direction of a Honorable High Court passed in a writ proceeding is to be dispensed with. Now, my lords, kindly see the show cause with regard to why they say it has to be left. Show cause filed on 10th of the Chief Secretary. Kindly see that. They say, my lords, read it with that. My lords, they say in the show cause, my lords, that on 6/8/2004 a decision was taken to file an appeal. Now that statement your lordships will find, para 11. And an LPA with defect token number was filed on 17th. Read this paragraph with para 1 of the IA. The intent is clear. I have taken a decision to file an appeal. Your direction can rest, Lords, as a decorative piece on the record. My intent and my reflection is I will not comply with this. That is the intent.
Now you tell us that what order is to be passed. We have already said that as to why this contempt proceeding be not initiated. They have come up with a reply that they have removed the defect, the LPA is defect free. There is an order that it will be taken up in usual course. So there can be no reason for not complying with the order because the cases will be taken up in usual course. Now you comply, but then you tell us that why have you not complied? Because there is no stay order.
There is no stay, my lord. The case could not be taken up, my lords, because of.
That's right. The case could not be taken up because when you mentioned the matter, maybe Honorable Chief Justice did not think it proper that it is an urgent case.
My lords, we mentioned.
You failed to convince.
We failed to convince, my lords.
Fair enough. It's not that. You failed to convince that it is an urgent matter. So you complied.
That's why, my lords, only for
Conditional, I heard Mr. AG referring that, subject to the orders that may be passed by the division.
Yes, you comply the order subject to that may be passed by the division. Then I will not pass any further order for compliance.
My lord, definitely. Yeah.
I will just pass an order that I am not satisfied. Now on the quantum of punishment, the matter has to be fixed. This is it. I think this is the procedure.
No, yes, possibly, my lords, last time your lordships had indicated that the proceeding for contempt is to be initiated.
Yes, this is what
Plus
I
the
explained.
registry under the High Court rules, if your lordships will see 393, it has to be in Form 1. My lords, I am only pointing.
Therefore, I do not want to be procedurally incorrect.
Therefore, my lord.
Right? I am absolutely satisfied that contempt has been committed.
My lords.
I have no doubt on it.
My lords. And
Now, because contempt has got two parts. One is the timeline, other is the direction. So both the parts are to be complied with in less than space.
My lords.
They have not done it.
Not done it.
Fair enough, they have not done it. We don't want to say anything more. But what is the procedure as per
My lords,
the
I
High
will
Court
pass
rules?
on, my lord, 390. It starts from
Because
387.
I have never initiated any contempt proceedings against
My lords,
anybody
my
so
lords,
far.
kindly see Rule 393.
I don't want to commit any error.
Lord, should
in
I
that.
pass on this? I have flagged it and I highlighted it.
You have a copy for yourself?
I'm not sure I remember it. I have the Patna High Court rules. We have the
Yes,
same.
Not appear.
Yes.
So it has to go in Form 1, my lords. Form,
Okay.
and a date has to be fixed. Form 1, my lords, mandates that the contender has to be present in person before this court.
We'll issue.
My lords, our IA is on record, my lords.
Yes, we will
My
we'll
lords.
consider that idea. Don't worry about it.
And was my submission only that we have got the LPA number and this case is not defective, it is likely to be.
No, we can't take your
My
submissions
lord,
like
that
that.
only the LPA number.
We do not.
LPA.
LPA, whatever you have stated in the supplementary affidavit, it has been mentioned. Now the case is going to be taken up in usual.
My lords, only the LPA number, this is the update portion. Only to
LPA
that.
number is mentioned in the
LPA number
supplementary
नहीं था, filing number
affidavit.
था.
नहीं,
नहीं, LPA number नहीं था, filing number था.
supplementary affidavit में LPA
Filing
number
फाइलिंग नंबर था. LPA नंबर जब डिफेक्टिव हो जाता है तब LPA नंबर मिलता है my lords.
अच्छा, LPA filing number.
हाँ. So we get the LPA number as per the new SOP after the case is now defective. So we have got the LPA number, my lords.
Plus one other aspect, my lords. Whether it is the Chief Secretary, aided and abetted by another top bureaucrat of this state, or whether it is at the behest of a top bureaucrat of the state, namely the Principal Secretary, Road Construction Department, that the Chief Secretary is filing in tow. I will only point out few things which transpire from the show cause of the Chief Secretary read with para 7 of my
We need
supplementary.
not do anything more. We are only concerned with our direction, and then we will issue a form 1. ask the registry to issue Form 1. That's it.
That's it. No, so this delays mine, but yet I wanted to be true to this court and point out that there is under the rules some procedure prescribed.
Yes, kindly. Therefore, you see, it's a very serious matter. So we expect that senior advocates would give us proper assistance, that there should not be any procedural irregularity in the matter of mediation.
That is why I pointed out, my lord.
Kindly let me know what is that. This one?
No.
This one, Form 1.
Form 1 is 393 prescribes for Form 1.
This
Form
is the
1
next
is
step.
Form 1 is enclosed to the High
This is
Court.
the next step. This is issuance of a bailable warrant.
My lord, sir, possibly not.
Kindly read it. इनको Form 1 दिखाइए सर.
No, since the format is there, my lord. Whereas your attendance is necessary, so and so, you are hereby required to appear in person.
After 2405 form is there.
You shall attend the court in person this day and shall continue to attend the court and so and so. Herein fail not. Okay, that's Form 2.
Oh, that is Form 2.
Form 1 is there.
We'll ask him to appear in person on next Friday. Next Friday, is he available? He'll make himself available.
My lords, he has to be, because Form 1 has to be issued and
We'll issue Form 1. Right?
my lords, may I be permitted to place my IE?
Yes, you place your ID.
My lords, if
You place your ID.
my lords, para 5 of IA number 9990 of 2024.
Verify.
That against the judgment date so and so, filed in so and so, the Road Construction Department has preferred an appeal being LPA filing number 8361/2022 under oath number 14/8/2024, which was filed on 17/8/2024, which is pending before the division bench of the Honorable High Court. All defects into defect pointed out in subsequent stamp reporting in the appeal so and so, and the matter is pending for listing. I'll skip thereafter. Para 8, my lords. That decision for filing the appeal was taken on 6/8/2024, whereafter the appeal was drafted and affidavitted, para 8, on 14/8/2024 and filed on 17/8/2024. The decision for filing appeal was taken much prior to issuance of the notification date 16/8/2024. Even the oath was affirmed on 14/8/2024 and 15/8 was holiday, and relevant formalities like so and so was completed, and after the appeal was filed on 17 without any further delay. And my lords, I was placing para 18 and 19, my lords. 16, 18, and 19.
16. Yes.
It is therefore paid that before your lordships to grant an opportunity to the opposite party to have the list settled once and for all and to pursue the matter before the Honorable High Court. There is no willful and deliberate violation on part of the opposite parties, as the opposite parties pray before this Honorable Court not to proceed against them in the instant contempt apprehension till the final disposal of LPA number so and so. It is humbly submitted that in adherence to decision, the Honorable Supreme Court of India in S13 also has expressed sanguine hope that the learned single judge would show deference to the pending appeal and take up the hearing of the contempt issue only the reviewing bench of the Honorable High Court so permits. And the opposite parties pray for unqualified apology. And para 21, my lords, there is no intention on our part, my lords. The
Because the Supreme Court order that they have enclosed makes an interesting reading. In what fact, circumstances of which case, and the very first line, we decline to interfere in the application under 136. At the highest, they say, show deference. And order passed by the contempt court will not be given effect to in those particular facts for a week only. And that is why I was pointing out dates to show that nearly 50 days have elapsed, 42 days have elapsed.
And so far as my assumption, why there is no willful and deliberate violation, a bona fide appeal has been filed first. We have also mentioned the appeal and
No, you have not said that you have mentioned that.
my lord, it is supplementary. If Lordship may kindly permit me to refer to the
You mentioned and the Honorable Court says that it will come up in
but we
later
mentioned
course.
it, my lords. We have
That's
mentioned it.
So
Now,
the Honorable Division Bench has not fixed any date.
it did not, my lords. It did not. So this may be kindly considered, my lords, that for a thing to qualify as a willful and deliberate violation, because in contempt, the important aspect is there has to be a willful and deliberate. A bona fide appeal which has been filed, Lordship, please. A bona fide appeal which has been filed, a decision taken much prior, subsequently the appeal was also mentioned before the Honorable Division Bench. The Honorable Division Bench has directed that this matter to be listed in usual course. As on today, means as on 20th September, we have got the LPA number 489 of 2024, which testifies that the appeal is defect free. And as such, my lords,
So you mentioned a defective appeal before the Honorable Division Bench?
my lord, on 10th, my lords, we mentioned before the Honorable Court,
A defective appeal?
my lord, that this appeal there were certain typed
I
copies.
want to know that you have got the number only yesterday, according to you.
LPA number yesterday.
So you mentioned a defective appeal?
Today. We mentioned on the basis of filing number, which is permissible, my lords. We do mention on the basis of filing number. And this was mentioned on the basis of filing number itself, my lords. Lordship may kindly turn up my supplementary affidavit dated 12th 9 September 2024.
You see, we are issuing
My
Form 1. We are putting a date for his appearance.
My lords.
You can have a stay by the Division Bench. What's the big deal about it?
The only aspect is, my
No,
lord, there is no
you see-
willful and deliberate violation so far as we are. My humble submission.
See, I have already expressed
My
that
lords.
we are satisfied that there is a contempt
Contempt
made
made
out.
That's
I will give a date for his appearance, and in the meantime,
as your
get
lordship,
an order.
as your
There
lordship,
is
my
no
lord,
problem
because
about
this is the only aspect on which my humble submission is. This needs.
I am
this
just
may be
putting
listed.
it only on next Friday. You say that your matter is likely to be
Listed
taken.
on
We do
Tuesday.
not know. We
My
will
lords.
not record such
Definitely,
things
definitely,
because
Only
the
the LPA number
submissions
we
which you have
recorded.
made earlier, nothing has
My
come
lords.
up. We do not know.
Only
what
the
you are
LPA number
going to
we
do.
mentioned. This is the only extra thing, my lord, which I was humbly submitting. That we have got the LPA number and this is defect.
Now, since your lordships have already said it aloud that your lordships are convinced, intent, para 1, read with the...
Intent has been expressed and in so many words in the final judgment itself.
My lords.
That you have not treated him fairly. It is very, very serious.
And now then the notification dated 16/8/2004,
Yes.
about which they say the chief secretary doesn't say that he doesn't know it. He says that
I'll quote that order, and then since till now there is no interim
Alright.
order, I will deal with your IA. I will whatever some
My lords.
order has to be filed, passed on your
Definitely,
IA.
definitely, my lords. So this is my humble submission, my lord. Nothing beyond that. There is no willful and deliberate violation, my lord. This is our humble submission. We have bona fidely preferred an appeal and pursued this.
because I was sitting here, I heard that the government law officers ought not to be, there should be a wakalatnama. Because that is coined in Rule 394. Kindly see why, my lords. Likes of my learned friends, assistant to prosecute and assist this court could be required, right? Kindly see Rule 392.
Once 393
Yes,
form is
entered-
issued,
Just a moment.
once form is issued,
394, kindly see, my lord.
once the form is issued,
The
thereafter
court
it-
may direct the Advocate General or any other state counsel to appear and assist the court. And the contemptor has to be represented through his private counsel.
Yes.
my lord, that is after 393.
No, even
Not at present.
Acha, ठीक है, now
I think at the initial stage only, while issuing notice, I have mentioned that he can represent himself through an independent counsel.
Yes.
Normally I do that.
And my lords, I will rely upon a...
Just a moment.
There is an honorable Supreme Court judgment which,
Lord's order dated
which
9/8/2024.
permits us to represent the government officials even. I'm just putting this in the notes.
Second order, my lord.
Yes.
That's, I was only pointing it out, my lord.
That is all. You have received the copy? LPA?
Yes, ma'am. Both hard copy and soft copy.
KBT is already there on record.
Contempt Civil 683 of 2024. Third, the Learned Senior Counsel appearing on behalf of the petitioner, Mr. Jitendra Singh, Senior Advocate, assisted by MS Amrita Singh. Third, Mr. Ashutosh Anand, Learned AAG Learned 3, representing the state. And also the Learned
Opposite parties, the opposite party.
and also the opposite party number 2. The Learned Counsel for the opposite party has submitted that pursuant to order dated 31/8/2024, show cause has been filed on behalf of opposite party number 2.
On 10th of
On 10th of September 2024, indicating the timeline indicating that there is no willful or deliberate violation or willful, deliberate or intentional violation of order passed by this court, and the LPA and giving the filing number of LPA being LPA filing number 8361 of 2024. A copy of this is show cause or idea. A copy of meaning thereby a copy of the order passed by the Honorable Supreme Court in special leave appeal within bracket C number 5289-5291 of 2021 has also been annexed along with the supplementary show cause. It has been further mentioned therein that the decision to file appeal was taken on 6/8/2024 and appeal was drafted and filed on 17/8/2024, and the decision to issue notification dated 16/8/2024 was taken prior to filing of appeal, and this notification is regarding posting in the
posting, yes, but you have recorded it in detail in your
relates to,
lawsuit's order dated 31/8.
Notification dated 16/8/2024 referred to in order dated 31/8/2024 was taken prior to filing of appeal. The Learned Counsel has further submitted that a supplementary affidavit has been filed on behalf of opposite party number 2, stating that stating that the matter was mentioned, but the matter has been directed to be listed in usual course. he has submitted that yesterday only the LPA number has been
Today.
Today.
Rectified
LPA number,
yesterday only.
The defects were rectified yesterday only, and the appeal number has been given as LPA number 489 of 2024. The Learned Counsel has submitted that all steps have been taken for listing of the LPA, but as per supplementary affidavit, there is a direction to list the case in neutral courts. The Learned Counsel has also referred to IA number 990 of 2024 to submit that the hearing of this petition be deferred till the final disposal of the LP. The Learned Counsel appearing on behalf of the petitioner has opposed the prayer and has submitted that the order and has referred to the order dated 31/8/2024 and has submitted that this court has already expressed prima facie that the opposite party number 2 has no regards to the orders passed by this court and has acted in a manner to frustrate the judgment by issuing notification dated 16/8/2024. The Learned Counsel has also submitted that in the judgment passed by this court, it was clearly observed that the petitioner has not been treated fairly at the hand of the respondents.
No, your lordships have also at para 51 talked about a judgment of this Jharkhand High Court saying declining officiating arrangement, and that letter was addressed to the Chief Secretary, then Chief Secretary.
Yes.
That has been quoted by
The
your lordships
Learned Counsel
at
has also
para 51.
referred to para 51
Para 51 of your lordship.
of the judgment passed by this court and has submitted that earlier also there have been orders directing the Chief Secretary not to make officiating arrangements. Para 51 को थोड़ा quote करें.
Quote करें.
I will just see.
No, sir, I have checked it up. I am correct with regard to the
Para 51.
Page 68.
page 16.
The Learned Counsel has also submitted that once the Honorable Division Bench has observed that the matter has to be heard in usual courts, there can be no reason not to comply with the order passed by this court. He submits that the petitioner is scheduled to retire on
No, 31st of December 2020.
31st of December 2024, and if the petitioner attains the age of superannuation, then the fruits of the judgment passed by this court can never be given to the petitioner. He has reiterated that petitioner is the only officer in the state of Jharkhand who enjoys the post of, who has been promoted to the post of Engineer-in-Chief cum Additional Commissioner cum Special Secretary. And by the conduct of the respondent, opposite parties, they have deprived him of the rank, status and the post. As of now, the petitioner is posted nowhere.
No, sir, actually, in law posted nowhere, your lordship can say that.
Is posted nowhere.
I had
As
applied
the
to be
posting of
relieved,
the
they are not
petitioner
posting
to the vigilance
I had
department.
applied to be relieved, they are not relieving me. How do I know Then they will say, we have taken a decision to file appeal and you are absenting
As
it.
on date, the petitioner stands nowhere in view
In
of
law.
the fact, nowhere in law, in view of the fact that the posting of the petitioner to the vigilance department has been set aside by this court.
Absolutely.
He has also submitted that the interlocutory application seeking deferring the hearing of this contempt petition be dismissed. After hearing he has further referred to Rule 393 of the Jharkhand High Court rules and submits that a notice is required to be issued to the opposite party number 2 in form 1 by the office of this court. An appropriate order be passed to that effect. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that while judgment dated 15th of July 2024, which was uploaded on the same date, the opposite party number 2 was directed to take a decision with regard to the petitioner in connection with this posting within 15 days. The order having not been complied, the petition for contempt, for initiating contempt proceedings was filed before this court on 5/8/2024. The notice to the opposite party number 2 by speed post was directed to be issued on 9/8/2024. As per when the matter was taken up on 23/8/2024, the filing number bearing 8361 of 2024 was provided and was mentioned in the order. Admittedly, the appeal was filed only on 17/8/2024. It is the matter was then taken up on 30th August 2024, wherein it was informed that the defect in the LPA has been cured and the matter was directed to be posted on 31/8/2024 to inform this court as to whether it was submitted that the defect would be cured on the same day and the matter was directed to be posted on 31/8/2024 to inform this court as to whether the defects have been cured or not. It was submitted on 31/8/2024 that the defects in the LP has been cured, but the number could not be obtained. However, on 31/8/2024, a detailed order was passed by this court, which is as under. I quote the entire order, so it is self-speaking. After considering the entire facts and circumstances, this court prima facie observed that the opposite party number 2 has no regards to the orders passed by this court and has acted in a manner to frustrate the judgment by issuing notification dated 16/8/2024 and thereafter filing the LPA. And opposite party number 2 was directed to show cause as to why a contempt proceedings will not be initiated. The show cause which has been filed by the opposite party number 2 essentially refers to filing of the appeal. The supplementary affidavit reveals that the Honorable Division Bench has directed the matter to be posted in usual course. In such circumstances, there can be no justification there could not have been any justification for the opposite party number 2 not to comply the order of this court and file a compliance report to purge the complaint, to purge the contempt itself. However, However, instead, the learned counsel for the opposite party has again insisted that the hearing of this petition be deferred by referring to the interlocutory application. This court is not at all satisfied with the show cause filed by the opposite party number 2, including the supplementary affidavit. This court is of the considered view that once the Honorable Division Bench has observed that the matter is to be heard in usual courts, there can be no reason for non-compliance of the order passed by this court. And this court finds no justifiable reason to proceed further in the contempt proceedings.
Not to proceed.
Not to proceed further in the contempt proceedings. So far as the order annexed with the show cause passed by IL with the interlocutory application, दोनों में लगा है ना? Passed by the Honorable Supreme Court in special leave to appeal number 5289-5291 of 2021. This court finds that the state was in appeal against the order of learned single judge who had issued a contempt proceedings on account of non-compliance of order passed by the court during pendency of the appeal before the Honorable Division Bench. The Honorable Supreme Court declined to interfere with the order and observed that the respondents were free to request the division bench to expedite the hearing of the pending appeal. This court finds that the respondents have already taken steps for expeditious disposal of appeal by mentioning the matter before the Honorable Division Bench, but the Honorable Division Bench has refused to fix a date in as much as it is their own supplementary affidavit to reveal that the matter has to be heard in usual course.
Would your Lordship like to use the word expeditious steps? Defects being cured after
this court. This court also finds that
some steps.
In view of the aforesaid facts and circumstances, once the matter is to be heard in usual course, and consequently there is no interim order of stay passed in favor of the opposite party, this court is of the view that the present proceedings cannot be deferred, and accordingly IA number 9990 of 2024 is hereby dismissed. And the show cause filed by the opposite party number 2 having found to be not satisfactory, this court directs the office of the Learned Registrar General, office of this court, to issue notice to the opposite party number 2 in form 1 in terms of Rule 393 within bracket Roman 1 of Jharkhand High Court rules. The
date will also have to be
fixing the date of appearance before this court. Personal appearance of opposite party number 2 before this court on
this next Friday would be 27th.
Because notice has to go, and thereafter, as per 393(2), is required to file a show cause. So these
No, this is after post show cause.
Just a moment.
This is post show cause.
And 396 says that notice has to be served personally along with all the documents. 395.
Let's see, we'll do that.
Just a moment. today is 20th, right?
My lords.
On 3rd of October. Okay. On 3rd of October,
Time may also
2024,
be fixed since he has to be.
at
3rd is Thursday, my
10:30.
lords.
So,
हम बस बता रहे थे.
on 3rd of October 2024 at let it be 4th of October. It's the last working day.
All right.
At 10:30 a.m.
My lords, as the first lords.
It is, however, observed that it is still open to the state
That is
to
judicious.
mention the case before the honorable division bench as the
Malords will not do that. Malords
No, I will just
Malords will not do.
in case just one observation, in case the state is able to obtain an interim order of stay by the honorable division bench, the opposite party number 2 need not appear on court.
Malords, and then if you're adding that, then your lordships may even add that in case the direction is complied with
Or in case the direction is complied with, right?
and notification is the issue.
In case the direction passed by this court is complied, or if an order of
Stay
or
there.
interim order is obtained by the honorable division bench, the opposite party number 2 need not appear on court.
My lords. Much obliged.
Also, case from supplementary list item 3, Resolution 1435 of 2016.
कोई बात नहीं, सर्विस हो गया होगा, इससे कोई मतलब नहीं.
Conviction is 498A. So that is conviction. Sentence 3 years. R plus fine. Up to 2,000. And in the other one,
Just a minute.
sentence of 1 year I.
How many persons are there? One person.
Yes. The others have already been admitted.
Okay.
4 persons were admitted.
Husband is the petitioner.
Yes.
Okay. He has been convicted under section 498A and section 4. 498A में कितना सजा है? 3 साल?
3 years I plus 2,000 fine.
Fine 2,000. 4 DPS.
1 year I for 1 year. And
1 year.
fine up to 1,000.
1,000. DPS. Value provision. Then, what is your point?
Well, my point is it's a case in which the general allegation has been made against all the family members omnibus regarding the alleged incident of torture having taken place at Gaya in the matrimonial house of this informant PW3. But there was another allegation, another part of the allegation, that was that she was reached and left at her parental house at Bhimishpuriya, where also it is said that once this husband came there, made a demand and assaulted her. This was the difference of allegation made by this informant. Now the court's finding, if your lordship kindly sees, so far this Tilaiya matter is concerned, there is no evidence brought on record by the same prosecution to establish the allegation. If the Lordship finally sees what has been considered by the court below, page 28, in at page 7 of the judgment of the trial court. Now this is something peculiar I find here in this case, paragraph 14. अभियोजन साक्ष्यों के शब्द से यह भी प्रमाणित होता है कि कुछ घटना झुमरी तिलैया कोरमा स्थित सूतिका के घर में रखी हुई झुमरी तिलैया में कथित घटना की संलिप्तता केवल पति सुनील कुमार के विरुद्ध प्राप्त हुई, जैसा कि एफआईआर में सूचिका ने कहा है. Now this FIR story, FIR allegation is made the basis and has been considered to be sufficient for
Informant is witness number? PW3.
PW3. There are 4 witnesses only. They have to read this FIR first. Four political witnesses have been examined. PW1 PW1 is residing at a different place, Saru की लड़की शबनम, which is informant. PW2 is the father. In a fire, and the story of this informant PW2 was that from the very next day, when she reached her matrimonial house after marriage, the torture started and the demand started. Now kindly see what the father says at paragraph 1 itself. 8/12 तो मैं अपनी बच्ची शबनम की शादी सुनील कुमार पिता सो के साथ किए थे. हिंदू रीति रिवाज शादी
सर आप अपना परवर्सिटी बताइए, ऐसा हम पूरा एविडेंस यहाँ पे नहीं पढ़े. आप बताइए कोई स्पेसिफिक पॉइंट बताइए तब हम लोग इसके प्रोसीड करें.
So far my point is that so far this allegation of 498%, it is of two places. One is at Gaya, the matrimonial house, and the other is at Jhumri Tilaiya. Jhumri Tilaiya, no evidence has been brought, and FIR cannot be formed the basis for conviction. which I read out from the order, from the judgment. Now, so far the Gaya is concerned, my lord, that story has been disbelieved by the learned trial court. Now, my humble submission is when the major part of the story, there are two parts, same set of witnesses, same set of evidence. If one part, the major part has been disbelieved.
Where do you say, from where do you say that the entire incident at Gaya has been disbelieved by the prosecution?
Because of the acquittal of all the...
Where is it? Let us see, where is the acquittal?
Yes, madam. That is at page 28 in at page 7 of the judgment. Para 13 पढ़ देते हैं। उक्त अभियोजन साक्षियों के साथ से स्पष्ट होता है कि सूचिका शबनम देवी की शादी सुनील कुमार के साथ हुई थी। शादी के बाद सूचिका अपने ससुराल मानपुर में गई। वहाँ पर सभी अभियुक्तों द्वारा 1 लाख रुपया बाकी दहेज की मांग की गई। सूचिका के पिता द्वारा उस मांग को पूरी नहीं करने से अभियुक्तों द्वारा सूचिका को प्रताड़ित करने की बात प्रमाणित होती है। अभियोजन साक्ष्य के साथ से यह भी प्रमाणित हो जाता है कि घटना झुंडी तिलैया कुंड में हुई है, नैहर में भी हुई है। झुंडी तिलैया में कथित घटना की संलिप्तता केवल पति सुनील कुमार के विरुद्ध प्रमाणित होता है। जैसा कि एफआईआर में सूचिका ने कहा है, मेरे पति रात को करीब 9 बजे पिता के घर पहुंचा, पकड़ कर रोने लगे। मेरे पति ने मुझे मोहल्ले वालों के सामने, न मानने वाला है उनके नियम के सामने मारपीट करने लगे और बोले कि वहीं पर रहकर भी 1 लाख रुपया लाने को पिता से लेकर आओगी तब आना। उक्त कथन से कथित आरोप अभियुक्त सुनील कुमार के विरुद्ध प्रमाणित होता है। अनुसंधान कर्ता के द्वारा घटना स्थल में तिलैया स्थित सूचिका के पिता के घर भी बताया गया, किंतु गया में घटित घटना के बारे में पूछे जाने पर अनुसंधानकर्ता ने स्पष्ट कहा कि मानपुर दुर्गा कॉलोनी जिला गया में घटित घटना का उल्लेख नहीं किया है। इस बात से आदमी के ससुराल में घटित घटना की सत्यता पूर्णतः सत्य प्रतीत नहीं होती है। And this was the reason for acquittal of all those persons. Therefore, I said, if the same PWs are not believed for first part of the allegation, they can't be believed or said to be wholly trustworthy to hold this person guilty. और ऐसा है भी, इसमें एक चीज और देख लिया जाएगा जो कि आई थिंक मैडम काइंडली सी दिस 313 एग्जामिनेशन। में कहीं रिसीव फॉर्म
बताइए क्या बोलना।
313 में there is no question put regarding any incidents having taken place at Jhundi Tilaiya, that is her parental house. Only one question has been put, and that has been put to all the accused persons regarding demand and torture at Gaya. हमें सुनील कुमार the visa position. The finding shows that the IO did not find any such material regarding the incidents at Gaya. At Tilaiya, incidents is alleged to have taken place that has not been supported by this. Now this informant says that from the very second day of the marriage, she was subjected to torture. Whereas the father says that no, 1.5 years she was kept properly, and thereafter this incidence of demand has been made. So far the demand is made, that is a general and omnibus allegation against all the family members who have all been acquitted.
Yes, state.
There may be minor contradiction, but the offense is made out as 198A and dowry prohibition. Here, petitioner has been convicted under section 4 of dowry prohibition, which is demand of dowry. But from the record, it is apparent that dowry 1 लाख रुपया कम हुआ था, इसका मतलब कि dowry लिया गया था, इसलिए इसको सेक्शन 3 में कन्विक्ट करना चाहिए, जिसमें मिनिमम पनिशमेंट 5 years and 15,000 और amount of dowry.
Minimum punishment 5 years.
5 years.
किसमें?
3 में.
Section 4 में conviction.
हाँ. 4 में तो 6 महीने.
6 महीने. That's all. Heard the learned counsel for the petitioner. The learned counsel for the petitioner submits that although there are concurrent findings recorded by both the courts, but the improved judgments of conviction are perverse and call for indifference. The learned counsel submits that petitioner, being the husband, has been convicted for offence under section 498 capital A/34, 498 capital A of Indian Penal Code and section 4 of Dowry Prohibition Act. He has been sentenced for 3 years under section 498A with fine of rupees 2,000 and 1 year under section 4 with fine of rupees 1,000. By assessing the improved judgments, the learned counsel submits that the petitioner faced the trial with other family members and there was general and omnibus allegation against all the persons relating to the incident at Gaya. And the only allegation in connection with Jhumri Talaiya, that is the parental house of the informant wife, was that the petitioner had left her at Jhumri Talaiya while she was pregnant, and when the demand of dowry of 1 lakh was not satisfied, but it was stated in the FIR that the petitioner had assaulted the informant in Jhumri Talaiya as well, but such incident at Jhumri Talaiya was not proved by the prosecution, and the trial court has convicted the petitioner by referring to the allegation made in the FIR. The learned counsel has also submitted that no specific question was to the petitioner under section 313 in connection with the incident at hand. The learned counsel submits that the investigating officer had not made any investigation in connection with the incident which had taken place at Gaya, and all the accused persons were acquitted except the petitioner.
Acquitted, sir.
All other co-accused persons were acquitted except the petitioner. The learned counsel, appearing on behalf of the opposite party, state has opposed the prayer and has submitted that there are concurrent findings recorded by both the courts, and there is no scope for reappreciation of evidence in revisional stage. The learned counsel has also submitted that the petitioner has been rightly convicted based on materials on record, and the sentence is also appropriate. That is all. Order is on. We all need.
My lord, एक appearance मेरा देखिए serial time में on behalf of respondent.
हम नहीं लिखा सकते हैं, बाद में पेरेंट्स नहीं रिकॉर्ड कर सकते।
My lord, serial number 9 matter for this case Adalat.
देखना है।
My lord, opposite party has given consent.
Serial number 9 में with the consent of the learned counsel for the petitioner and the opposite party number 2, let the matter be placed before the ensuing Lok Adalat.
My lords, in another case, my lords, on the last occasion, my lords had instructed us to file judgments. My lords, in that Upendra Prasad, it's a commercial appeal, my lords, so my lords was sitting in a division bench. I just wanted to seek permission to file this, to submit this judgment compilation, my lords. In that case, it's listed on upcoming Monday before the late edition.
What was the matter?
This is the frame which was issued by her ladyship was whether any stay petition could be filed subsequent to filing of the appeal, because in that case there was a delay of some 20 days, and though the appeal was filed in 2019, this limitation was filed in 2022 or 2023. So there are a couple of judgments which have also
Not
ladyship.
stay petition, but whether the defect can be removed. Petition for condonation of delay, not stay.
But my sincere apologies, Your Lordship, it was on the
I had also referred to certain judgments.
My lords, we have
wherein the defects were to be cured within a reasonable period after
My
it was
lords,
pointed out.
it was pointed out that it's a curable defect under Order 41 Rule 2A, my lords, under CPC.
Okay, we'll see that.
My lords.
दो कॉपी यहाँ क्यों दे रहे हैं?
But it was since it's a DB matter, that's why I'll.
अच्छा वहाँ पर.
I'll take it before her.
No, we will pass it on.